To start off our symposium, we are pleased to welcome Professor David Uhlmann. Professor Uhlmann recently completed his service in the Biden administration, where he served as the Assistant Administrator of the Environmental Protection Agency within the Office of Enforcement and Compliance Assurance. Prior to his role, he served in the Department of Justice for 17 years, the last 7 of which he was Chief of the Environmental Crime Section. Professor Uhlmann is also active in academia. He joined the Michigan Law faculty in 2007 and has published prolifically on environmental crimes. Please join me in welcoming Professor David Uhlmann to the podium.
Good morning, everybody. Thank you to Todd. Thank you to Madison and to all the students from the Villanova Environmental Law Journal. And thank you to Villanova Law for the opportunity to appear before you today. It's nice to see so many of you here, so thank you to folks who are attending as well, and to my fellow panelists who are now scattered throughout the room, avoiding the front row, as Todd has noted. I'll say that Villanova and actually the law school world and EPA have one very important feature in common, which is Fridays are pretty quiet days in the building. But it's good of all of you to be here. I agreed to talk this morning about environmental enforcement from 3 perspectives. First, by offering a normative model about how we should think about the role of enforcement. Second, by talking about what we accomplished during my tenure as EPA Assistant Administrator. And third, by sharing my thoughts about what might happen in the Trump administration. But before I turn to those topics, I feel compelled to express my concern about what is happening right now in our nation's capital. I recognize that there are a wide range of political views in this room. In my view, respectful and robust debate between people with different perspectives makes us stronger. I also recognize that elections have consequences. But the last 18 days have brought an unprecedented assault on the rule of law, the balance of power between the White House and the Congress, and the institutions of government and the career civil service system that provide essential services to Americans and protect us from innumerable harms. There is much to be said, particularly in a law school setting, about the importance of upholding the rule of law and the value of remaining ever faithful to the balance of power set forth in the United States Constitution. Given our topic this morning, however, I want to focus on what is happening to my former colleagues at EPA and the Justice Department. They are not serving in lower productivity jobs in the public sector that we should encourage them to leave for higher productivity jobs that might be available to them in the private sector. Nor are they part of some dystopian deep state that controls our government. They serve in Republican and Democratic administrations, working on behalf of communities across America and carrying out administration policy whether they agree with it or not. Their public service is the highest of callings and should be celebrated, not denigrated. They are inspectors who make sure that drinking water systems are safe. They are compliance officers who help small cities and towns, as well as regulated industry, meet their obligations under the environmental laws. They are Superfund attorneys who ensure that polluters not taxpayers, pay to clean up hazardous waste sites. They are biologists, chemists, hydrologists, and engineers who ensure that we can breathe clean air and have healthy rivers and streams. We are less protected as a country when career senior executive service members at the Justice Department, including our government's leading experts on civil and criminal enforcement of the environmental laws, are reassigned to a heretofore non-existent Sanctuary Cities Enforcement Working Group. We are weakened as a country when everyone working at EPA and the Justice Department faces a fork in the road about whether to continue in public service, uncertain about whether they will have jobs that they choose to stay, or administrative leave with salary and benefits if they depart. We face a less hopeful future as a country when more than 1,000 talented new employees at EPA, many just a few years out of law schools like this one, may have their lives and their careers upended because they chose public service over the opportunity to make much more money in the private sector. The same is true for newly minted attorneys hired through the Justice Department's Honors Graduate Program, who for the first time ever have been told that positions they accepted at the Justice Department will not be honored. It is not permissible to reassign members of the senior executive service who lead the Justice Department's environmental enforcement efforts to a non-existent office. It is not lawful to fire civil servants without cause or to place them on indefinite administrative leave. Nor is it legal to reclassify civil service positions as political appointments by the stroke of a pen without going through notice and comment rulemaking to reverse existing civil service regulations. These actions exact an enormous personal toll on career civil servants, which is at once cruel and unjust. What the Trump administration is doing also sends an unmistakable message to everyone working in the federal government that their work is not valued and that they will not be supported by President Trump. But it is not just civil servants who are in jeopardy. If the current assault on the federal workforce continues unabated, the resulting chaos will affect everything from Social Security checks and funding for medical care and scientific research to the safety of our air traffic control and drinking water systems. We will be less able to protect communities against deadly chemical accidents and train derailments. Millions of people living in the United States will suffer, including people in so-called red states that helped elect President Trump. I don't think any of us want to return to the spoil system of the 19th century or the smog and rivers on fire of the 20th century. Nor do I think any of us want to plague our children and our grandchildren with a perilous future in the 21st century. So please hear my concerns as a nonpartisan appeal to shared values about how we treat one another, how we look out for those who are less fortunate than us, and how we promote a sustainable future. With that in mind, the normative idea that I want to promote today is that we should strive to reclaim bipartisan support for environmental protection in the United States, and that environmental enforcement should never be partisan. Over the past half-century, under presidents of both political parties, we have made great progress addressing the challenges that led to the enactment of our environmental laws in the 1970s. Our air is cleaner, our rivers and streams are healthier, and we have far fewer hazardous waste sites. We've achieved those successes because of conscientious companies across America who care about meeting their environmental obligations, and the vigilance of EPA and the Justice Department when companies break the law and put profits before the health of our communities. Despite those successes, we face numerous challenges, starting with the existential threat of climate disruption, the scourge of PFAS contamination, and the reality that for too long, the worst effects of pollution have been visited upon overburdened communities. Meeting these 21st century environmental challenges warrants the same bipartisan support that Congress provided when it created our environmental law system in the 1970s and the 1980s. A changing climate with searing heat, wildfires, worsening storms, and increasing drought does not care whether we are conservatives or progressives, Republicans or Democrats. The obligation to protect military families and farming communities from PFAS contamination likewise should not be a partisan issue. The same should be true when we talk about promoting environmental justice, which is the idea that everyone living in the United States should be able to breathe clean air, drink safe water, and live in communities free of toxic pollution. How we enforce the environmental laws in the United States also should not be a partisan issue. We should support the efforts of companies with strong ethics and integrity and sustainability programs who meet or exceed their obligations under the environmental laws. Companies that are good corporate citizens who make the investment necessary to comply with the environmental laws should not be at a competitive disadvantage with polluters. But companies who break the law and expose our communities to harm must be held accountable. We must uphold the rule of law and never waver in our commitment to fair and robust enforcement based on the law and the facts and the obligation to protect communities across America from harmful pollution. There is no room for politics in the enforcement of the environmental laws. Different administrations have different priorities and will make strategic choices about where to devote enforcement resources. But there should never be favored industries or disfavored industries depending upon which party holds the White House. There cannot be one set of rules for some companies and a different set of rules for others. We must always enforce the law fairly and without prejudice. It may not surprise you that these have long been my views. And it therefore also probably is no surprise that the normative model I just described was a central feature of my leadership of EPA's Enforcement and Compliance Assurance Program. I spoke whenever I could about the environmental values that I've just described to you, and my belief that we should once more find common ground in support of environmental protection. I also insisted that we keep politics out of EPA enforcement, even when it was not popular to do so, and regardless of whether the entreaties to proceed differently were coming from inside the administration, from Capitol Hill, or from somewhere else. I testified during my confirmation hearing in September 2021 that my priorities would include pivoting the enforcement program at EPA toward addressing 21st century environmental challenges like mitigating climate change, addressing PFAS contamination, and promoting environmental justice. I also stressed the need to revitalize EPA's enforcement program, which had suffered from a decade of budget cuts and had lost 30% of its personnel. I'll briefly discuss each of those areas, as well as two significant paradigm shifts in how the enforcement program operates that we pursued during my tenure. First, I announced in September 2023 EPA's first ever climate enforcement and compliance strategy, which prioritized climate change mitigation and climate resilience. Last year was the hottest year on record, breaking the record set in 2023, which broke the record set in 2022. 19 of the hottest 20 years on record have occurred in the last 2 decades. And we have had more billion-dollar weather events in the United States the last 2 years than ever before in our country. In the last year, actually just since last fall, we saw devastating impacts from hurricanes, both along the Gulf Coast, where that typically occurs, and hundreds of miles inland near Asheville, North Carolina, where it is highly unusual. Over the last several weeks, we witnessed the worst wildfires in U.S. history in and around Los Angeles, made worse by conditions wrought by climate change. Simply put, climate change is an existential threat, the ultimate 21st century environmental challenge. And we must do everything possible to keep it from making the world uninhabitable, even as we develop greater resiliency to prepare for its inevitable consequences. EPA also included mitigating climate change as one of EPA's 6 national enforcement and compliance initiatives for FY 2024 to FY 2027. FY is government speak for fiscal year, while also adding new initiatives to address PFAS exposure and what's referred to as coal ash contamination. The Climate Change Initiative focuses on methane releases from the oil and gas sector and from landfills, which are the second and third leading sources of methane emissions in the United States. The initiative also includes the global phase down of hydrofluorocarbons, or HFCs, which along with methane are the 2 climate superpollutants most responsible for near-term climate change. PFAS are ubiquitous, present in the air, the water, and the soil in communities across America, and already bioaccumulating in all of our bodies. The PFAS initiative focuses on PFAS manufacturers, federal facilities that have caused significant PFAS contamination, and companies who use PFAS in their products. The goal of the enforcement initiative is to characterize, control, and eventually clean up PFAS contamination, paying particular attention to PFAS in drinking water supplies. Coal ash contamination is a byproduct of decades of coal consumption in the United States to meet our electrical needs. So in that sense, perhaps a problem that originated in the 20th century, or even the 19th. But as we transition away from coal consumption and toward greater reliance on clean energy, the legacy of coal contamination is very much a 21st century environmental problem. Coal ash threatens drinking water supplies and places communities at risk to carcinogenic wastes, most often in communities that already are overburdened by other sources of pollution. In that sense, coal ash is another example of how we historically have visited the worst pollution in the United States on communities that already are struggling economically and from a public health perspective. For that reason, EPA made the moral imperative of promoting environmental justice one of its top priorities during the Biden administration. EPA finally began making good on promises made in 1994 when President Clinton signed the first executive order mandating that the federal government promote environmental justice. In the enforcement program, promoting environmental justice meant showing up and listening and taking action in communities that have been left out and left behind for far too long. Communities along Cancer Alley in Louisiana, communities in the poorest neighborhoods in Puerto Rico, and communities in Appalachia and across the heartland that have been hollowed out by years of industrial decline. More than 60% of our inspections and more than 50% of our cases were in environmental justice communities, helping to begin to right decades of environmental wrongs. In each of these ways, EPA over the last few years pivoted its enforcement program toward addressing the most significant public health and environmental challenges facing our nation, 21st century environmental challenges, which EPA is uniquely equipped to do and which provides extraordinary benefits to everyone living in the United States. That is work that should continue in the years ahead. Second, EPA made revitalizing its enforcement program a central goal throughout my time at the agency. EPA enforcement endured a decade of budget cuts beginning in 2011, the third year of the Obama administration, which ultimately cost the program 950 positions, or nearly 1/3 of its staff. Those budget cuts, combined with uneven support during the first Trump administration and the challenges of the COVID-19 pandemic, hollowed out the enforcement program in ways that left communities across America less protected. So one of my top priorities was making the case within EPA, at the White House, and ultimately with the Congress, that EPA needed more resources to have an effective enforcement and compliance assurance program. We secured more than 300 new positions through a combination of an annual budget increase in 2023, funding from the Inflation Reduction Act in 2022, and the reinstatement of the Superfund tax in 2023 and 2024. EPA also upgraded equipment and invested in training in ways that the agency had not done for more than a decade. the investments we made, more than 500 new employees at headquarters and across all 10 EPA regions, when you include vacant positions that we backfilled, paid immediate dividends in both 2023 and 2024. EPA conducted more inspections and brought more cases each year than we had in nearly a decade. We opened more criminal investigations each of the last 2 years than we had since 2013, other than an outlier year, 2020, when COVID fraud cases surged in the United States. But we did more than just bring more cases. EPA also brought bigger cases, like the Cummins and Marathon cases that are the largest Clean Air Act mobile source and stationary source cases that EPA has ever pursued. We concluded the Norfolk Southern case for the East Palestine train derailment, and with it, industry-changing safety measures to help prevent future derailments. We brought criminal, civil, and administrative cases for HFC smuggling and other efforts to evade the requirements of the Kigali Amendments to the Montreal Protocol, which, once fully implemented, will reduce global climate change by 0.5 degrees centigrade. Third, I mentioned paradigm shifts in how EPA administers its enforcement program, which I will briefly mention now and then perhaps describe further during the panel discussion. In April 2024, I announced EPA's strategic civil criminal enforcement policy, ushering in a new approach to how EPA includes criminal enforcement in its strategic planning and how the agency enhances cooperation between civil and criminal programs. As a result, EPA's criminal program is now part of the agency's national enforcement initiatives, which will increase the impact of those efforts. In addition, EPA is now screening all new matters to make sure that the agency is pursuing the most appropriate remedy and sharing information where legally permissible to ensure optimal results for communities. Then in December 2024, just 7 weeks ago, I announced EPA's policy on increasing case urgency to address 21st century environmental challenges. In part, this policy grew out of the recognition that if EPA is showing up for the first time in communities that have been left behind for decades, the agency needs to come back to those communities with results in time frames that are meaningful to those communities, lest they think nothing has changed. But in equal part, that policy reflects the view that if EPA is focusing on the most significant public health and environmental challenges facing our communities, it should be approaching those cases with the urgency that those challenges demand. A great example of EPA's increased urgency is how it responded to the Norfolk Southern train derailment, achieving settlement just 15 months after the derailment in a matter that previously might have taken several years to conclude. By the end of my tenure, EPA had restored a fair and robust enforcement program that holds polluters accountable and protects communities across America from harmful pollution. EPA is once more a force to be reckoned with for companies that break the law. EPA is achieving record settlements and even more impressive injunctive relief. EPA is bringing cases wherever the pollution is worse, including in historically marginalized and overburdened communities. EPA entered 2025 soaring as an enforcement and compliance program, poised for even greater gains in the years ahead across all of EPA's enforcement work. As my opening remarks suggested, the future suddenly is uncertain for the EPA enforcement program. What should be a record year in 2025, building off our accomplishments from October, November, December, and the first 3 weeks of January, as well as the dividends paid by 2 years of significant reinvestment in the enforcement program, now looks like it could bring significant retrenchment or worse. Key leadership at DOJ has been removed. New employees at EPA may lose their jobs. The fork in the road looms ominously. I'd like to think that a strong case can be made for continuing the work that EPA began under my leadership. A fair and a robust enforcement program is good for communities and ensures a level playing field for law-abiding businesses. A commitment to promote environmental justice does not involve racial preferences. Race was removed from EPA's environmental justice screening tool 2 years ago. Environmental justice work involves ensuring that everyone has the environmental benefits that many communities are able to take for granted. A stronger partnership between civil and criminal enforcement promotes greater fairness and greater efficiency. Increased case urgency also provides greater efficiency and real-time environmental benefits to communities. I will not be surprised if the new administration downplays the climate change work and even the environmental justice work that EPA has been pursuing. As I said earlier, elections have consequences, and each administration is entitled to emphasize its priorities. But it would be wrong for the new administration to abandon the climate work altogether, or to fail to conduct inspections and bring cases in communities that have suffered the worst pollution and need help from the federal government the most. I'll close with just a few words about the topic that we will address next: how recent Supreme Court cases affect the enforcement landscape. First, I expect that the demise of Chevron will limit EPA's more assertive regulatory efforts, although Chevron had been on life support for years. Courts rarely afforded EPA deference in recent years, so the significance of the Looper-Bright decision may be more symbolic than anything else. As for enforcement, EPA never was entitled to deference in enforcement cases, so the Looper-Bright decision should have minimal impact except where it limits regulatory protections. What may make a difference, and what merits watching as we go forward, is the Jarkissi decision, where the Supreme Court held that defendants in SEC cases were entitled under the Seventh Amendment to receive a jury trial. It remains to be seen how the Jarkissi decision will be applied in the environmental context. EPA has strong arguments about how to distinguish SEC cases, Securities and Exchange Commission for the uninitiated, from EPA enforcement. After all, the common law remedies that led to the Jarkissi decision are notoriously ineffective in the environmental context. One could say that we have environmental laws in the United States because common law remedies could not resolve modern 20th century and now 21st century environmental problems. But administrative enforcement is a big deal at EPA. we concluded approximately 1,850 administrative actions in FY 2024. So I'll be watching carefully to see how the Jarczy case law develops and how vigorously the new administration defends EPA's significant administrative enforcement authorities. Thank you for your attention this morning, as well as your interest in environmental protection and environmental enforcement. Despite the questions that have emerged over the last few weeks regarding the new administration's commitment to environmental enforcement, I want to reassure the students who are here that the work of public service, the work of public interest lawyers, and environmental stewardship efforts in the private sector have never been more important than they are today. The stakes are high for communities across America and for our future on this planet. So if you came to law school wanting to work on environmental issues, or if you discovered a passion for environmental enforcement or environmental protection while you were here, please do not lose heart. Keep the faith. Your work matters. Thank you again. I look forward to the panel discussion.